community that came out in the Kansas City Star this weekend. There's this little community in Missouri that they just can't seem to get over the Civil War. And so they're so adamant that they want KU to drop the Jayhawk as its logo. Because Jayhawkers, after all, are the ones that came across the border and burned down a town. And KU shouldn't be continuing to celebrate by having a Jayhawk as its mascot. So they're wanting KU to get rid of its mascot. So anyway, I just thought that was rather peculiar.
What town is it?
And so a city council basically passed a charter, or passed a deal that says, a proclamation or whatever, that says that they want KU to get rid of its logo, OCO logo. Since it's in public domain, I'll say it. They said they don't think it'll go anywhere because everybody that goes to KU are either uppity or arrogant. So, that's what it says. So. City officials in Osceola, southwest Missouri town of about 950 are asking University of Kansas to drop its Jayhawk mascot because the name refers to a group of domestic terrorists that nearly destroyed the city 150 years ago. Before they came in and killed a bunch of people and burned down the town, Osceola was about 2,500 people. Pretty good sized town for that era. It's never gotten back above 950 cents, so. I guess that was called cleansing. But anyway, another reason why we study politics and look at what's going on around us. I'm a little disappointed in that, by the way. I just think it's ridiculous to be doing that. That's a long time ago. Yeah. Well, if you read that in the Kansas City Star and you got a KU license plate rim on your car or something, and that may be a not good place to stop. I mean, you may not want to stop there and feel comfortable that you're stopping in a good place that is welcoming.
I guess my thing is, why bring it up now? Why not whenever the college was founded and they first picked the mascot?
Well, I agree. I agree. I mean, what's perpetuating this now? That's a fair question. I don't know. I mean, I can't imagine why they want to spend their time and resources on such a discussion.
I don't know. They had a reenactment up near Kansas City this weekend. Maybe they
brought back old memories.
Yeah.
Some of the people that were in the war 150 years ago still hold grudges. Yeah. You know, we don't really hold grudges over World War II with the Germans and the Japanese, do we? I mean, not really. I mean, that was more recent. And, pardon me? Yeah, we do? No. Oh. Well, having known both of them very, very well, I don't think we should or do at this point. We kind of have to look to the future and kind of learn from the past. Well, we're still talking about civil liberties. I'm going to talk today. We talked about the First Amendment principally last week, I think on Wednesday a little bit. We would have talked about it on Friday, but I want to pick up with the Second Amendment to the Bill of Rights, and it has to do with the right to own and bear arms. There are competing competitions about what the Second Amendment pertains to. Does it pertain to an individual and his or her right to own and bear arms? Or does it pertain to a militia, a group of people, and their right to keep and bear arms? And so we're going to talk about that in a case in just a few minutes, Washington, D.C., District of Columbia versus Heller Amendment. And of course, the Second Amendment has generated significant disagreement between gun owners and those who favor limits on firearm ownership. Again, this tends to be a wedge issue. You have people that are pretty much on both sides of the issue, not too many people in the middle. Either you do or you do not want people to own arms, typically. In District of Columbia versus Heller, the Supreme Court ruled that the Second Amendment confers an individual right to citizens to keep and bear arms for protection. And this is the website where you can get a one-page summary of that case. But let's take a look at the case. Heller is an off-duty security guard. He wants to carry his service revolver home with him when he gets off duty, and he wants to keep it in the privacy of his home for his own personal protection in the District of Columbia. Well, the District of Columbia has an ordinance that if you do have a handgun, it must be registered, obviously, but it also, if you're going to have it in your home, it either has to have a trigger lock mechanism on it, be unloaded, or it must be disassembled. Well, Heller is making the argument that, well, that doesn't do me much good. I mean, if I've got it in my home for my own personal protection, I can't be fumbling around with it, putting it back together when someone's breaking into my house with the intent of doing me harm. The same thing with a trigger lock mechanism. I mean, it's not going to do me, and being unloaded, it's not going to do me much good if someone's on top of me in 30 seconds after they come through a window, and here I am trying to get my trigger lock undone, and doing a Barney Fife, I'm trying to put a bullet in the chamber. So anyway, that's kind of what the case is about. And the facts of the case are these. For the first time in 70 years, the Supreme Court heard a case regarding the central meaning of the Second Amendment. So it's been a long time, and we're talking about 2009. So it's been a long time. After the district passed legislation barring the registration of handguns, requiring licenses for all pistols, and mandating that all legal firearms must be kept unloaded and disassembled or trigger locked, a group of private gun owners brought suit claiming the laws violated their Second Amendment right to bear arms. The federal trial court in Washington, D.C. refused to grant the plaintiffs relief, holding that the Second Amendment applies only to militias such as the National Guard and not to private gun ownership. So you have a federal district court interpreting the Constitution on the side of militias and not personal gun ownership. That's a little bit disheartening for some, but that's how a federal district court would interpret the Constitution. The U.S. Court of Appeals, however, for the District of Columbia Circuit, disagreed with the trial court, voting 2-1 that the Second Amendment does in fact protect private gun owners such as the plaintiffs. The question in the case is simply this: whether provisions of the D.C. Code generally barring the registration of handguns, prohibiting carrying a pistol without a license, and requiring all lawful firearms to be kept unloaded and either disassembled or trigger locked violate the Second Amendment rights of individuals who are not affiliated with any state-regulated militia, but who wish to keep handguns and other firearms for private use in their homes. Well, again, the Supreme Court gets the opportunity to hear a case that it hasn't heard for 70 years, and the Supreme Court has been very hesitant to get involved in Second Amendment issues because they would prefer that the states address Second Amendment rights. Well, the District of Columbia is not one of the 50 states. It's a federal jurisdiction, so it felt compelled to get involved in this case. Well, here's the decision of the court. The court decided on a vote of 5-4 that the Second Amendment rights does include individual right to own arms. So they sided with the Court of Appeals, who had overturned the original decision at the federal district court level. The court held that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that firearm for traditionally lawful purposes such as self-defense within the home. The court based its holding on the text of the Second Amendment as well as let's remember that statement. The court based its holding on the text of the Second Amendment, as well as of applicable language in state constitutions adopted soon after the Second Amendment. Justice John Paul Stevens argued that the Second Amendment only protects the rights of individuals to bear arms as a part of a well-regulated state militia, and not for other purposes, even if they are lawful. We've got a court decision that's almost split, 5-4. If you were a Second Amendment advocate, you'd be a little concerned about that, perhaps, about where the court may decide next time. I ask you to remember the wording of the Second Amendment. And so let's look at the wording. Who are my English majors in here? Who's majoring in English? Anybody? Who ever thought about majoring in English? Well, let's look at the way this second amendment is written. Let's look at the importance of how commas are used. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed.
Period.
The court looked at the right of the people to keep and bear arms as a standalone provision within the amendment because commas were on the left and the right of that. So if we read this sentence without the commas, it would maybe perhaps take on a somewhat different meaning. So let's read it without the commas. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. You could make an interpretation that the people are necessary to stand up for a militia. And oh, by the way, those people need arms, but only those people with arms are going to be in the militia. So you can make an argument, but the commas become very important, don't they, for purposes of interpreting that? Wouldn't you agree? Well, that's why our framers were so brilliant, because they did understand the use of grammar. So this isn't a grammar course, but I just want you to understand the importance of certain meanings on how they were interpreted by the Supreme Court. Any questions on this? The Supreme Court would prefer that this remain a states' rights type issue and matters be solved at the state level. For instance, in the state of Missouri, we have conceal and carry. Some states don't have conceal and carry. We also have the Castle Doctrine in the state of Missouri, which was passed a couple years ago, which allows for somebody to protect their castle. Your castle is where you are. We already kind of talked about that, I think, before. Freedoms of practice, controversy over Second Amendment rights to bear arms, perceived intrusions on free speech and assembly, criminal due process, the U.S. Patriot Act, FISA court. You know, some of us have a totally different appreciation of what privacy means. I would venture to say that 90% of the people in this room have a lot different viewpoint on what privacy means as compared to maybe what I thought privacy would include when I was of your age, most of your age. I may have mentioned before that when I was growing up on our phone was part of a 14-member party line. Did I mention that in here? Mm-hmm. So when I picked up the phone, I was very lucky to be able to get a line that I could call out on because Margie Stevens or somebody else may be talking on there. And you can hear the whole conversation. Well, when I was talking to my little girlfriend, I mean, I know Margie was sitting there listening to the whole conversation. The reason I know she listened to the conversation because the entire conversation showed up in the Vedette newspaper the following week. And the only reason that could have gotten there is because Margie called the editor to let know what David Jerome was doing with his little girlfriend, what they were talking about, what they were getting ready to do. So my idea of privacy was I didn't have any on the phone. But back then, that's kind of where it began and ended with regard to my expectation of privacy on using some kind of communication device. Back then, no one had a personal computer. Absolutely nobody had one. The only computer that I was aware of was at the Empire Bank in downtown at Glynstone and Sunshine in Springfield. And the only reason I know it is because we took an FBLA tour and looked at the basement. The whole basement consisted of a computer, which now is replaced by something that's no bigger than this. We didn't have cell phones. Nobody had a cell phone. We had some ham operators, radio operators. But we had nothing like we've got today. So I couldn't be Googled back then. Nobody knew where I was at unless they hired Dick Tracy or somebody. You don't know who Dick Tracy is, do you? Well, anyway, today, you're in the public domain almost constantly. for those of you that are twittering as I'm talking right now, I mean, you're basically in communication with somebody. I hope you're not twittering, by the way, or tweeting, or whatever it's called. But you're on the cell phone a lot. Society is on the cell phone a lot. You're on the computer a great deal. You're on the internet a great deal. Your expectation of privacy has to be a lot less than what mine was. When I get on the cell phone, I have to assume, it doesn't go back to my party line days, but I have to, and it's based on other experiences, I have to assume that when I'm on a cell phone, that somebody could be listening to the conversation. Because it's happened to me before. You know, I was sitting in the privacy of my living room one evening, and all of a sudden, my phone vibrates or does something, and I pick it up, and there was already a conversation taking place between a friend of mine and his wife. And I was listening to the conversation, and I didn't feel comfortable with it, but for some reason, I got included on the conversation, and it wasn't intended for me to be in that conversation. So I closed up my phone and acted like I never even heard anything. Well, that happened to me when I was negotiating a contract one time, because I didn't do protect keys on my phone, and when I had my cell phone on my belt, and it hit the side of the chair, and it called my wife automatically. And all of a sudden I heard this little voice, "You called me!" And I'm sitting here negotiating a contract, and I hear my wife's voice somewhere. And I reach down there and, oh, there she is. But I also have, you know, a different background than most of you do here. I mean, I was a veteran. I'm a veteran. I was in the military for a long time. And security clearances are big where I come from. And you never take anything for granted about who may be listening to you and what they're going to do with the information they pick up from you. So, who cares if government's listening to your conversation or not? Because of what happened to us on 9/11. If it's going to save lives, if the idea is that they're going to save lives with the information they're able to gather by listening to conversations. You know, millions and millions and millions and millions and millions of conversations that take place every day are not going to be listened to by the federal government. Because they're listening for certain things that's going to catch their attention. And then they'll start listening. But I don't think the federal government at NSA headquarters in Fort Meade, Maryland, is going to be interested in the phone call that I'm going to make to my wife around noon today to see what's going on. I don't think they'll care anything about that. But if somebody from offshore calls me and starts using words like bomb, kill, the infidels, all those types of words in the same sentence, then that may catch somebody's attention. And they may want to listen to my conversation I'm having with somebody. Is that reasonable? I guess that's the question. Is that reasonable? If you're having that conversation, you're not supposed to be having that kind of a conversation. Because not all speech is protected, is it? Speech is not protected if it's going to harm somebody else.
Right.
So what's your reasonable expectation of privacy in that regard? If you're not making a threat on somebody else, then you shouldn't matter what you're talking about. Just some GS-13 sitting in Fort Meade, Maryland is going to be listening to a conversation and getting bored to death because he doesn't care what you're talking to your other half about. This is a very controversial issue. Some people think that people in the Bush administration ought to be indicted for war crimes for doing something like this. Or how dare they listen to our conversations. So it's something for you to think about. How do you feel about it? Why do you feel the way you do about it? Because you're told to? Because your friends feel strongly about it? Does anybody have any idea what I'm talking about? Because I'm getting that vibe that maybe I'm not registering here. Does the book not talk about the FISA court? Okay. Freedom of Information. Security Act. So where do you stand on Second Amendment rights? Do you believe This is where I'm asking you your opinion, because again, my opinion doesn't really matter for much, does it? It's really what you think. Does the Second Amendment guarantee to all citizens the right to own a gun? Or does it protect that right? 4 justices of the U.S. Supreme Court 3 years ago made the decision, in their decision on this case, that it only pertains to the militia or National Guard, the right to own handguns. 5 justices just 3 years ago said no, it applies to everybody. The question is, how do you fall on with regard to the Supreme Court's decision just 3 years ago? Chances are some of you are going to say, well, I agree with the minority decision. Some of you may agree that I agree with the majority decision. Why are we having the discussion? Hello? Why am I having the discussion? How many of you think it's all right for everybody to own a handgun if you're not a felon? If you're not convicted of a felon, have not been convicted of a felon, how many of you think it's all right to own a handgun? How many of you think that it's the only purpose that the Second Amendment had in mind was to allow for an armed citizenry for purposes of raising a militia to keep us all protected? Well,
Seriously, did they have to ask that question?
no,
I mean,
no,
we
no,
have,
That's my question.
I mean, the history shows that the reason why our forefathers wanted us to have guns, to protect ourselves against the enemy, foreign or domestic.
Yeah.
So I'm disappointed in the fact that there's 4 people on the Supreme Court that think that it only applies to.
Well, Don, let me ease your mind. I would be disappointed. I think it's important to have the discussion.
Hmm.
My concern is, how are people looking at the original intent of the amendment and coming up with 2 different interpretations? Some people would say they're not looking at it with regard to the original intent of the framers. The conservatives tend to look at they're strict constructionists. In other words, they believe that the Constitution means exactly what the framers said it meant. More of a liberal standpoint is, well, we have to adopt the Constitution to include amendments and apply it to our times in the modern era.
Yeah.
So you have those 2 ideological viewpoints that are in a combative relationship. So that's really what we're talking about.
I think a lot of it's maybe like a biased point of view.
Oh, sure, absolutely. In what regard were you thinking?
Well, maybe personally their own thoughts on it instead of like what the Constitution would actually.
That's what we get when we have 9 strong personalities only sitting on the Supreme Court making the ultimate decisions on behalf of everybody. Some people aren't comfortable with that. That's the reason that people take a hard look at who the president nominates to be on the Supreme Court, because literally that person could be on the Supreme Court and shape the court's decisions for 30, perhaps even up to 35, 40 years. Because the only way you're going to impeach that person, to get him kicked off, is if they go to some movie theater and expose themselves, or they get caught drunk driving, or they beat their spouse, or whatever, they misbehave in that regard. They're not going to get impeached. So they're going to be with us a long time. A new president getting elected that disagrees with the justices cannot boot him off, no matter what he does. You just can't do it. Doesn't have the power to do this. So it matters who we put on the Supreme Court, especially if we feel strongly about some of these issues. Roe v. Wade, that court lined up for a woman's reasonable right to privacy under the 14th Amendment. Reasonable right to privacy included up to her decision to have an abortion. The Supreme Court made that decision. That same decision would not be made today with this current Supreme Court because of the conservative nature of the bench. They would not have ruled in favor of Roe v. Wade. So freedoms of religion, privacy, and criminal due process, the 4th, 5th, 6th, and 8th amendments ensuring due process. The 8th Amendment, protection against cruel and unusual punishment. Well, I've asked you to read the Constitution in Chapter 2, right? So I'm assuming that you've read the Constitution. When I'm up here lecturing to you, I'm assuming that you're understanding what I'm saying when I talk about the Bill of Rights and when I'm talking about what's in the 4th Amendment, the 5th Amendment, the 6th, etc. The authors talk about in 8, protection against cruel and unusual punishment. What is cruel and unusual punishment? Pardon me? Torture. What is torture? Everything that the Bush administration was accused of with regard to waterboarding, I've been through that training as an Army officer. There's not anything that I can think of that the CIA or other agencies have done with regard to terrorists in Guantanamo or wherever that I haven't been through. I was never waterboarded, but I do know somebody that was because I heard it across the desert floor for several hours. I mean, did I tell you about my experience in doing that? I mean, I was basically in an escape and evasion course for 30 days. And the idea for most of those days was not to not get caught in the mountains of Colorado. And you're out there kind of with a couple of other buddies, and you're just hoping you don't get caught and get put into the SEER compound. It's basically a survival, escape, resistance, and evasion type compound where they take you in and they put you through a process that you hope you never go through again. And so you can imagine how your voice carries across several thousand meters at 3 o'clock in the morning when you're on one mountain and something else is taking place on another mountain. You got all this desert floor between you, and you're just hoping you don't get caught. There's this old Army boxer. His last name was Washington. He got caught. I think they wish they didn't catch him. But anyway, they waterboarded him. And you could hear him yelling and screaming clear across the valley floor. Then they put him in this big plywood box. And they started throwing water in on him, water hoses, fire hoses. They threw a couple big snakes in there on top of him and refreshed their pleasure. Well, he turned that plywood box into a box of toothpicks. He literally tore it to pieces coming out of it. And so, anyway, I'm just letting you know, we do that to our own people because we need to know what it feels like on a person that we're trying to harvest information from. I can't dance and I can't sing, so I don't know what else to do to wake you up this morning. You can't wake up to a story like that. I don't know what else to do. Waterboarding is when you put somebody on a slab and you use a towel, kind of circle around their head. There are different ways of doing it, but this is the one I'm familiar with. You kind of circle a towel around the face. You take a water hose and you kind of